All right. Well, thank you for that. Yes, my name is John Dillon. I have law firms, the Dillon Law Group. We're in Carlsbad, California. I'm born and raised in San Diego, so this is my hometown by every sense of the meaning and words there. But so we're going to talk about some case updates on Second Amendment litigation that are going on in California and in the Ninth Circuit today. But before that, I wanted to kind of go over a little bit of the background when it comes to how we got to where we are litigation-wise and kind of the political and legal landscape that we're dealing with. So let's go all the way back to 2008. We get the decision out of the Supreme Court, District of Columbia v. Heller. And that case essentially affirmed your individual right to keep and bear arms. Up until that case, a lot of states interpreted the Second Amendment as a collective right that was based off of a militia membership. DC v. Heller said no to that. It was dealing with a DC handgun ban, but they essentially affirmed your individual right, disconnected from militia service, to keep and bear arms. In that decision, it was a fairly simple decision if you read it through. Based off of a historical perspective and looking back on the history of firearms regulations dating from the founding era and shortly thereafter, the Supreme Court said, hey, look, the Second Amendment protects all bearable arms that are in common use. And because of that, handguns, being one of the most common firearms that people choose for various lawful purposes, including self-defense, we can't ban handguns. And that was essentially what we got from the DC v. Heller decision. Shortly after that, we have the McDonald decision in 2011, which incorporated the Second Amendment to the states. So basically saying that the Second Amendment applies to state laws and state restrictions. Now, with those two cases, you then have a good 10-year, decade-long period where lower courts took these decisions, which again, I'll say, very simple. When you read through it, you don't need a crazy legal mind to understand what the court's saying. They lay it out pretty explicitly. But over the next decade, you saw a lot of the lower courts, district courts, courts of appeals, especially in the Ninth Circuit, that kind of created their own bastardized version of what the Supreme Court said. They made their own constitutional standard of, well, how are we supposed to decide if a law that's being challenged is constitutional under the Second Amendment? And what they did is that they started doing this interest balancing means end scrutiny analysis. Now, what they did, to dumb that down a little bit, is a law would be implemented. Let's say it was the 10-day waiting period law in California. So you go and buy a gun, you do a background check. Even if you get immediately approved, you still have to wait 10 days, and the state justified that by saying there needs to be a cooling off period, right? And that apparently will stop a person who's intent on murdering someone. If he just waits 10 days, that intent to murder someone's just going to go right away. They'll change their mind, they'll be fine. So in a case like that, there's actually a case that challenged that specific law back in the day. And it essentially said, I'm a CCW holder. These were the plaintiffs in the case. And they came in, they said, I literally have a gun on my hip when I go buy another gun. I instantaneously pass the background check because I'm a lawful CCW holder. I shouldn't have to wait 10 days. I should just be able to get my gun once I instantly pass the background check. The state knows I'm not a prohibited person, and we're good to go. In the arguments in court, the state argued that, well, you could still want to murder someone with that new gun. And yeah, exactly. So, we're sitting there going, so I have a gun on my hip. I want to buy another gun. The state's justification for this 10-day waiting period is I need 10 days because maybe I don't want to kill the person with the gun on my hip. I want to do it with my new one. And they thought that was a sufficient reason. Now, under the old standard, the court sided with the state. They said, this is a perfectly valid public safety interest that we need to uphold and support, and therefore this is not a violation of the Second Amendment, and problem solved, case dismissed. Now, as a lot of your reactions to my description of this, that's a pretty messed up way of looking at life and doesn't make a lot of sense, especially in that case when the state literally brought zero evidence of any kind that a 10-day waiting period had ever stopped, inhibited, deterred a single individual ever from committing any type of crime. So that's what we were dealing with for the last decade, where you would bring a legitimate Second Amendment challenge to a clearly unconstitutional restriction on your right to keep and bear arms. You go to the state, or you go to the courts, and the state would just raise the age-old argument. Well, this is for public safety, and that's why we've implemented this. No matter the fact that we have no evidence that this actually does anything to increase public safety, we have no evidence to justify it in any real way. The interest balancing that the courts would implement, or the tiers of scrutiny that they would use to analyze these cases, they'd essentially always favor the state and the public policy interest balancing, interests there. So we dealt with that for a good 10 years. Now, recently, in the last 2 years, we had the Bruen decision. And now this was the latest and the most recent time the Supreme Court had taken up a Second Amendment case since McDonald in 2011. And to give you a different perspective, like First Amendment cases are heard all the time by the Supreme Court. I mean, there's hundreds of cases that have been dealt with when it comes to the First Amendment. The Second Amendment had two cases that addressed the entirety of the Second Amendment. So you can see how that was really just weighed differently in the eyes of the court for a very long time. So Bruen came up. This was a challenge to New York's good cause or good reason requirement when it came to CCWs. And what you saw was in a lot of the media when the Supreme Court had their decision, they said, hey, this good cause requirement is invalid and unconstitutional. So all across the country, you saw a lot of media talking about how, hey, good cause is no longer a thing, CCWs are allowed everywhere. And that is the case. They did rule on that specifically. But the major change that happened with Bruen was the Supreme Court took these decades-long interest balancing, tiers of scrutiny analysis that courts have been implementing across the country, and they said, look, this is not the test that you get to apply to Second Amendment challenges. You can't do interest balancing. You can't do any type of means-end scrutiny. You don't get to weigh the public policy interests to justify your law. That's not what the Second Amendment's all about. It's not what Heller said, and you're doing it wrong. So the huge part about the Bruen decision was that it changed the way courts are allowed to analyze Second Amendment challenges. And what it did now is the court said, look, the first and foremost thing, and I think a lot of you will appreciate this, is you got to look at the plain text of the Second Amendment. What does it say? The right to keep and bear arms shall not be infringed. So you got to look at that first. And what does the plain text of the Second Amendment say? Now, the plain text says you have the right to keep and bear arms. What are arms? Arms are anything that you can use for offense or defense and that you can hold, basically. Anything that you choose, and it is your choice, is going to be protected. And once you can show, based off of the plain text, that the arm in question or the conduct in question is protected by those plain words and plain meaning, the burden now shifts to the states and to the governments to now justify their law that they're trying to implement. So to give you that earlier example, in a 1 in 10, or the 10-day waiting period law. So I got to go up and say, hey, I have a right to keep and bear arms. That encompasses the right to acquire or purchase arms, right? That's covered by the plain text very clearly. Incidental to the being able to keep and bear arms, I got to be able to get one in order to, keep it and hold on to it and bear it in public. So I've proven that part of the court's analysis by showing that, hey, this falls under the plain text of the Second Amendment. As soon as I do that in court, the burden goes over to the state now. The state now has the burden to affirmatively justify their law based off of a historical tradition. And what that means is the courts have to go back during the founding era when the ratification of the Second Amendment first took place and look at the landscape of the laws and regulations surrounding arms. And they have to see that there is a long historical tradition of relevant analogous regulations that would justify this current law. So they got to go back, again, in the 10-day waiting period, they got to go back and see, all right, were there laws and regulations that were implemented during the time of the founding era and shortly thereafter that restricted people's ability to go into a store or shop, buy a gun, and walk out at the same time? Was there any type of timing delay, background check, 10-day waiting period? Well, it's very clear when you go back to the founding that there was nothing like that during the founding era and with regard to Second Amendment or arms regulations of any kind. And so the state has a big hill to climb. Instead of it being a big hill for the plaintiffs to justify our constitutional rights, now it's a big hill for the states to justify these absurd regulations. Excuse me. So that's kind of the change in the landscape, and because of that, this is a hugely significant change. And like I said, it kind of puts the states back on their heels when it comes to Second Amendment challenges. And because of that, in states like California, who have a long history in the last 20 years of just implementing some of the most absurd laws that you can possibly think of, some of the most restrictive and just flat out unconstitutional laws, we're now getting a lot of litigation in states like California against all these various restrictions. So, I'm going to go over some of these, some of the bigger cases today, kind of give you a little summary of what's going on, what the challenges are that are in these cases, and then kind of where these cases stand. But I'll let you guys know, I'm also, after that, I want to just open it up to questions, and we'll talk about this stuff. I'll answer any questions you guys have. So we'll get into it. So let's see. One of the first ones, this one got a lot of publicity a couple years back, and I think a lot of you will understand why, is Duncan v. Bonta. This was a challenge to California's high-capacity magazine restriction. So in California, they deem any magazine that holds over 10 rounds a, quote, high-capacity magazine. Extremely deadly, these pieces of plastic with a spring inside of them. We can't have more than 10 rounds. Now, why is it 10 rounds? No idea. There's no justification, cause, or reason that they decided on this arbitrary number. But California says that if you have a magazine that holds 11 rounds or 15 rounds, 16 rounds, or anything above, that this is extraordinarily dangerous to the public. We're all going to die, Armageddon, and all that. So in the Duncan case years ago, we had what a lot of people now refer to as Freedom Week, where the district court looked at the case and held that, and this is actually under the old standard, they held that this magazine restriction or prohibition was unconstitutional. And when the court issued that order, they enjoined, which means they put a pause or they stopped the enforcement of that law. And before the state had a chance to appeal, there's about a 7-day period of time where it was completely legal to buy, quote, high-capacity magazines in California. You could import them, you could manufacture them, you could buy them, transfer them, all that, unrestricted. And in that 7-day period, I will personally attest that California bought the entire country's stock of high-capacity magazines. I personally worked with a number of manufacturers during that time that they were out. They were out. Millions. I'm telling you, the country's whole stock was gone. Everyone didn't have anywhere else. Literally, people were denying customers in their own home states because everything was going to California. So, and here's the thing. That happened years ago. Are we seeing any crazy crime increase because of people having high-capacity magazines? No, we're not. So we had this Freedom Week, and everyone was really happy because you were able to exercise your God-given rights and your rights to keep and bear arms. Unfortunately, the court system got in the way. The state appealed. That decision or that injunction was put on hold. And the case has had an interesting history of going up and down the court system, the Court of Appeals. But right now, Duncan, it has been the en banc court, which is the full 11-judge panel. So when you go to the Court of Appeals, you're in front of 3 judges and you make your arguments. The en banc court is a random selection of 11 judges from the Court of Appeals. So it's a bigger panel that you're in front of. And right now, the Duncan case is being heard en banc. So we got an 11-judge panel deciding that case. And this is going to be implementing the new Bruen standard. Now, I brought up Duncan first because of the Freedom Week stuff, and also because there's other cases that kind of have been put on pause because of the Duncan case. So this next one would be Miller v. Bonta. This is actually one of my cases. We are challenging California's prohibition on assault weapons, or what they call assault weapons. This is any semi-automatic centerfire rifle that doesn't have a detachable magazine. It has a detachable magazine with any number of features, meaning the plastic pistol grips, adjustable stock, flash hiders, all that. These are the quote characteristics that make a totally normal semi-automatic centerfire rifle this amazingly dangerous, scary weapon that again cause Armageddon if anyone owns them. And again, if you are a gun owner and you even have one of these rifles, you know that it's an absurd claim to make, to say that if you have a pistol grip on your gun, that it magically becomes this crazy death-killing machine. It's not the case. So again, in that case, we actually won at the district court level before Bruen, and then we state appealed, but then Bruen came out, and so the case was sent back down, means remanded, and we had to do some additional briefing to address, hey, this new standard in Bruen. It's actually the standard that we initially made the same arguments for before the quote Bruen decision came out, because it's based off of the Heller decision. And so under this new standard, after we did the briefing, the district court again ruled in our favor, saying that the assault weapons ban is unconstitutional. And unfortunately, I know everyone was wanting this, but everyone was hoping for that Freedom Week again, where you could buy normal rifles without any type of state infringement. But the state kind of knew what was coming, so they preemptively said, hey, you got to stay this decision, let us appeal, because we're going to appeal, no matter what. And so you didn't get that Freedom Week, but so now we're on appeal in that case. We actually had oral argument in front of the 3-judge panel of the Ninth Circuit in January in Pasadena. Unfortunately, I think 2 days after the oral arguments, the court stayed our case, which means it put it on pause until the en banc panel decides the Duncan case on magazines, because they basically are saying, well, since they're dealing with the Second Amendment case and how we're going to apply the Bruen standard to, bearable arms, let's see what the court says there before we decide what's going to happen to here. So that's kind of where we are on the assault weapon case. Another one of my cases is the Chavez v. Bonta case. This is the challenge to the state's prohibition on legal adults or 18 to 20-year-olds from being able to purchase firearms. Again, that's a very interesting case where you got to go back to the founding era. Were there any restrictions on legal adults being able to purchase firearms? No. Yeah, if you are a lawful person that is not prohibited in any way, you should, and you're an adult, you should be able to purchase a firearm. If you can go fight a war for your country, if you can get married, enter into contracts, literally be, you're held as an adult under any criminal standard once you turn 18. I mean, in every sense of the word, you are a legal adult by the time you're 18, and therefore you should be able to purchase a firearm just like any other legal adult. So in that case, we've, again, back and forth when it comes to getting decisions and then having the Bruen standard come out. In this case, it was interesting. We initially lost our preliminary injunction motion, but then the Court of Appeals actually ruled in our favor, stating that it was, in fact, a ban. They remanded the case to back down to the district court to be reheard. Bruen came out, we did the Bruen briefing, and unfortunately, the court kind of ignored that Ninth Circuit decision and again denied what's going on there, but we're currently being in the process of doing summary judgment motions on that case, and we will be going forward on that one. So again, we have a number of other cases. Rena v. Bonta in California. This is a challenge to the handgun roster and micro-stamping requirements in California. So in California, there's a list of firearms that are handguns that are allowed to be sold in California because these are the safe guns. And it basically requires a magazine disconnect in the gun and also a loaded chamber indicator. But one of the most restrictive aspects of this law was the microstamping requirement. And microstamping is essentially a made-up theory where you can laser etch serial numbers onto the tip of a firing pin or the extractor on a firearm so that every time you fire a gun, it stamps the serial number onto the casing of the bullet, and and that'll allow law enforcement to track, shootings and all sorts of bad behavior when it comes to this stuff. But first of all, this technology has never been implemented on a firearm and never been successful in any way. Well, and again, anyone who's actually had any experience with a firearm knows that laser etching something on the tip of a firing pin, which is its only purpose is to punch into metal constantly, that stuff wears off. You can take a 99-cent file in one swipe and it's gone. So it's not going to actually prevent any criminal from, it's not going to catch anyone, essentially. And I personally have a major problem with it because, if you're stamping everyone's serial numbers on the casings, well, what happens to those who reload ammunition, where you're taking cases and you're reloading them? So are you going to have your buddy's serial number stamped onto your ammunition that you're using? Or I've always said since the beginning, well, if I'm a criminal and I want to just totally mess up this system, I'm going to go to a gun range. I'm going to pick up a bunch of people's brass that has their serial numbers. Then you go commit your crime and throw about 100 casings out there. Now I've put 100 different people in liability and under investigation for a murder. And that brings up all sorts of issues when it comes to Fourth Amendment, Fifth Amendment, Sixth Amendment. It's just an absurd thing. So you have that case. Actually, the microstamping part of that provision has been enjoined. And I think a number of you probably have noticed that there's been several firearms that have been placed on the handgun roster, which in recent time, handguns were not allowed to be put on this roster. So no new guns were being sold in California. And that's what this roster was. It was a slow-acting prohibition on any new firearm, which is just an absurd thing. I mean, a good example of that is you had, the Glock Gen 3 was the Glock that was allowed to be sold in California. I think the Glock Generation 3 came out in 88, 89, in early 90s. They're now on Gen 5 for Glocks, and I'm sure Gen 6 is coming out any time now. So the state was essentially forcing people to use, decades-old firearms that do not implement any new technology, any new safety, any new improvements. They're forcing people to use old guns, not allowing new guns to be on the roster. And what was happening is eventually manufacturers stopped making these old guns, right? Because they're old and they have new improved firearms. And so you had a slow-acting ban where you kept seeing more guns fall off the roster, but no new guns were adding to the roster. And so every year, more and more guns, smaller and smaller list of guns you're able to see. So that, again, that's being challenged in California. You also have a challenge on, it's Nguyen v. Bonta, which is a challenge to the 1 in 30 firearms purchase ban. So what that is if I go to buy a firearm, I can go pass background check, get my gun. Well, what if I want to buy another gun? Well, I have to wait 30 days before I can start the process of buying a new gun and going through the background check. And if I do that, then I'll get denied if you buy it before that 30 days is up, and you got to go through this whole process. So again, this is a prohibition on being able to acquire firearms. The state's justification for something like this is, well, we want to keep people from getting a bunch of guns. Like, we want to lower the amount of guns that people are purchasing. They're admitting they want to stop people from buying firearms. It's not just, they're not claiming that, we got to stop criminals from buying firearms. They're literally trying to prevent the proliferation of firearms, which that is the right to even bear arms. So they're quite literally trying to stop people from purchasing firearms. And any one of you, I'm sure in this room, there's a collector here or there. I personally am a collector. I mean, it's a pain to if I want to buy 2 guns that are rare that I'm trying to collect, that's 2 months. It limits you.
Is there cut out of these for like pistols or something that are sold in there?
No. So, and I'll give you an example. I actually bought a pair of old Colt Derringer revolvers that came as a set. I had to wait 2 months to collect those, even though I've done a background check. I can't count how many times over. They have every one of my fingerprints and handprints 10 times over. And I'm definitely not a prohibited person. But yeah, that's a 2-month process to get these 2 guns that I bought at the same time. So we have challenges to that. And again, going back to the Bruen standard, in each one of these cases now, because this is a prohibition or a major restriction on the ability to purchase or keep and bear arms, the state now has the burden of going back to the founding era and showing similar analogous regulations that did this. So back in the founding era, were there any laws or regulations that prevented you from buying 1, 2, 10 guns at a time? No, you could buy as many as you wanted. And despite what our president says, go buy cannons all day long. No one cares. And so, there's nothing that really justifies this thing. And I think in that case specifically, the biggest analogy that the state has offered is, well, back then, there wasn't mass manufacturing. You had to bring in parts and pieces of guns. So sometimes it took a long time to get your gun because, the guy was making it for you. And that's the same as us stopping people from purchasing firearms. And it's an absurd statement. Again, it makes no sense to anyone who literally takes a step back and just looks at it objectively like, hey, what are you doing here? So you have cases like that are just absolutely infuriating. We actually had a big win that came out just last week or 2 weeks ago. It was Linton v. Bonta. And this is a very interesting case because California, so if you're convicted of a felony, that's a lifetime ban, right? You can't ever purchase firearms anymore if you have a conviction for a felony. But there are people in other states. Other states have mechanisms to where, like, hey, I was convicted of a felony, a nonviolent felony. I was able to do whatever I needed to do. I was able to expunge or nullify that conviction to where that state, let's say it was in Arizona, Arizona says, no, you're good now. Everything's been fixed. You now have the right to keep and bear arms. We have no problem. So then I moved to California. California refused to acknowledge the fact that that felony conviction was vacated, nullified, and removed from this person's history, and they refused to acknowledge that the home state doesn't consider them a prohibited person anymore. And so California would be like, no, you're still a prohibited felon. You're still banned. You cannot purchase or possess firearms. And in this case, the court just recently ruled that that's unconstitutional. If you're coming from a place where they're like, no, you're good, you don't get to just retroactively go and say, no, not to us, even though we have no jurisdiction or ability to do anything. We're just not going to acknowledge that. So the cool and wonderful thing about this new standard is, states are now having to really justify these absurd laws that for the last decade they haven't had to justify. They literally would just go, it's public policy. We just want to keep people safe. Okay, and courts would sign off on that, no matter the absurdity of the restriction. Well, they don't get to do that anymore. And so we're seeing a lot of cases get filed. Been very busy in the last couple of years. But it really just shows the change of the landscape where now our rights are being respected. This is not a second-class right. The First Amendment, freedom of speech, courts would never have upheld restrictions on the ability for free speech or freedom of religion that we've seen on the Second Amendment. And that's unfortunately what the Second Amendment was. It was this second-class right, the right that no one really appreciated or acknowledged. I remember back in law school when I was taking constitutional law, we spent a month on the First Amendment. We got to the Second Amendment, the teacher said, this is the militia right. You can own a gun if you're a part of the militia. And then that was the end of the discussion. So that really just shows you what people thought of and what the courts unfortunately thought of the Second Amendment until the Bruen really set them right and said, no, this whole standard that you've been applying is wrong. It's explicitly rejected, and you can't do it anymore. We also have a number of other cases which I'd like to highlight because I think they're very important. We have, arms is a key word in the Second Amendment. It doesn't say firearms. It doesn't say gun. It doesn't say musket. It says arms. And so what does that mean? It means that we're not just talking about guns when we're talking about the Second Amendment. We're talking about all bearable arms that could be used for offense or defense. So because of that, we have a number of cases like Teeter v. Lopez. This was a challenge to Hawaii's ban on butterfly knives. Again, why butterfly knives were prohibited in the first place? No real idea because I'm sure a lot of you are aware there's not a lot of butterfly knife crime that's ever really happened. It's just one of those types of knives that people said, oh, that's spooky because you can flick it around a lot. And it's a pocket knife. That's all it is. It's all it's ever been. But states banned things like the butterfly knife. And the Teeter court, they ruled that, hey, this is unconstitutional. And what that means is, again, arms, knives, stun guns, batons, firearms. Sorry?
Blackjacks.
They haven't ruled on that yet, but yeah, there's another case, the Fouts case that recently came out of the Southern District of California that's ruled that California's ban on batons or billy clubs is also unconstitutional. I mean, think about it. What's a baton or billy club? It's a stick. It's a club. People have been using that arm since the beginning. I mean, we're talking about rocks and sticks here now. So these are arms, is what they are. And they don't get a lot of attention. You know, firearms get the brunt of the focus when it comes to these restrictions. But unfortunately, because of that, a lot of states enacted a bunch of very restrictive laws on other arms that no one really paid attention to until now. But the cool thing that I think personally is why these are important cases is the same standard applies. You're still applying the Bruin standard to these cases. These are still arms. And so good decisions, favorable decisions in these cases, they're favorable decisions for the Second Amendment. They're favorable decisions that we can rely on for firearms cases. And it starts setting in stone this Bruin standard that these courts don't get to pirouette and jump around and try to come up with new ways and new analyses to justify absurd laws. So that case actually just got granted an en banc review. So again, 11-judge panel. So that's going to be reheard very shortly. And then another one of mine is the knife rights v. Bonta. This is a challenge to California's switchblade prohibition, which also includes butterfly knives in the definition. But again, why a switchblade is prohibited in California, no idea. It's not a lot of, it's just a pocket knife. It opens and closes just like any other folding knife. It has this 1950s stigma with, from Rebels Without a Cause, that I'm running around in a leather jacket poking people with a switchblade. That's just not the case. And there's real no justification, just like firearms, especially when you go back to the founding era. Quite literally, everyone had a knife. You always carried a knife of some sort on you at all times. There were absolutely no restrictions when it came to buying, purchasing, possessing, transferring knives. And this is the thing. In all of these cases, the only real restriction that you could argue could ever possibly be pointed back to are various concealed carry restrictions, right? So there were restrictions back in the day on concealed carry, never open carry. So in all these states that ever prohibited concealed carry, they would say, but let's make sure. If you wear this arm openly, you're good to go. No problem, have fun. So that's really the only thing that they can point to. And in these states, their argument is, well, there was restrictions on concealed carry. So that means we can prohibit the purchase, possession, transfer, ownership of anything because there are a couple concealed carry restrictions. It's not the case, and I always like to point people back to D.C. v. Heller. They looked at this history from the founding era and through the early to mid 1850s, and they looked at all of these concealed carry restrictions, and that didn't justify a ban on handguns. So it's not going to justify a ban on any other type of arm, and that's just common sense. And if you want to come to a different decision, you are literally blind, closing your ears, eyes, mouth. You're not paying attention. There are a number of other cases that have been, challenged and lawsuits have been filed. Again, we have the 10-day waiting period, 1 in 30 purchase restriction. May v. Bonta was another one. This was the one with SB2. This was the Bruin response bill. So all these restrictive, commie, tyrannical states and governors, who I'm not going to name, got really mad when the Bruin decision came out. And they don't like the fact that they can't restrict every aspect of a constitutional right. And because of that, they enacted in California SB2, which basically said that even if you have a CCW permit, the entire state of California is essentially a sensitive place, and it's still illegal to carry your firearm. So that, of course, passed in this state, but it was enjoined rather quickly when it came to being litigated, and so that's also going through the courts now too. So at this point, I think I've given a good example of the various cases. There are many more. If you guys do have questions, I am totally open for that. I'll just say, raise your hand and let them bring a mic to you. That way we can get everything on the audio and so people can hear what you're saying. And yeah, we'll go from there. Got this guy up front.
Can you speak to the Judge Benitez ruling from last year?
So there's been at least 4 in the last year. So do you have... So let's see, October, November timeframe. Well, that he did rule on our assault weapons ban last year. He also ruled on the Fouts decision, which is the Baton case. That was the most recent one. Both of those were held to be unconstitutional. He ruled on, I was talking to the gentleman up front here, there was an ammunition restriction, which basically made it to where you had to go through a background check every time you purchased ammunition. And the thing that a lot of people don't understand is when you did that, the state recorded and put it into a database what type of ammunition you were buying, the make and the model, the caliber. And if you didn't have a gun registered to your name in California of that same caliber, you'd get denied, and there's a whole process to it. But they were literally, they're making a registry of how many rounds of ammunition you're buying, like to where they could look it up. And the scary part about that law is there's nothing, ammunition, what do we do with ammunition? You shoot ammunition, right? So it's an expendable item. So especially if I'm a competitive shooter, you may be buying tens of thousands of rounds a month, right? And that all goes into this database in California, and they're just racking up how many you're buying. But there's no mechanism to show the state or show anyone that you don't have this anymore. And I'll relate this to something that I personally hate and detest in every way, shape, or form, are gun violence restraining orders or red flag orders or 5150s, mental health involuntary holds in California. These are mechanisms that have little to no standard of proof for the allegations, and what they do is they trigger firearms prohibitions very easily. And so what you have is a GVRO issue where someone makes an allegation. Well, the state could just look up you on the app system and see that, oh, you own 20 guns. And in the last 10 years, because you're a competitive shooter, you have 1 million rounds of ammunition, even though in reality you don't. Well, you must be a mass shooter, because who would not want that many guns and that much ammunition? And that can be used in getting a GVRO or justifying a GVRO to the court, which again has a very low standard. So it is scary. This isn't just a Second Amendment issue. This is, Fourth Amendment search and seizure issues, Fifth, Sixth, everything. So these laws, they're not for public safety. They truly are not. How they are implemented, how they are used, how they are in fact abused, is to keep people from owning firearms, get as many people as they can restricted and prohibited in any way, shape, or form, and to deny your right. So, that was my little tangent there on the ammunition restrictions, but that was another one that Judge Benitez had in front of his court, and he ruled in favor of the plaintiffs there.
You mentioned that in 2011, the McDonald decision integrated the Heller decision to the states.
Yeah.
So how does that work with the spirit of Aloha? if they're supposed to be, if there's, can they just pick
Oh
and choose
yeah,
or deny
the
what they?
spirit of aloha. Yeah, that was a very interesting read when we got that. I'll tell you, that's the first time I've ever seen such an absurd statement come out of a higher court in any way. It makes no sense, and yeah, the Hawaii Supreme Court has essentially said we don't care about the Supreme Court. We don't care about any type of legal precedent. We don't care about the Constitution. It's the spirit of aloha, which the funny thing about that, I think the justification, where they justified an act where like the king of Hawaii at some point tried to club people to death, and he didn't because his foot got stuck in a rock. And because of that, we have a spirit of aloha that doesn't allow people to have arms. It's a crazy, insane decision that came out of that court. But it does show that, unfortunately, you have judicial activism, just like you have bias and activism in every aspect of life. That it's clear as day in that case. And it is just it's a middle finger to the courts and the Supreme Courts. I would be shocked if it didn't. I mean, allowing something like that is, you're getting into some dicey territory. Sorry?
That's how the Civil War started.
Yeah.
Federal laws don't apply.
Yeah, yeah, when there was, I know it got some publicity and everything, but there were some phone calls between me and a bunch of other people who do what I do that was just like, have you seen this? This is quite absurd.
Can you speak on SB 1160, the bill that they're trying to pass that's going to force all Californians to register their firearms?
Oh, yeah.
How likely is that to actually go through? It seems like the most unconstitutional thing possible.
Yeah, there's no doubt about it. That is a flagrantly unconstitutional law. What he's basically saying is they've proposed a law that essentially will make a yearly registration and tax on every single firearm that you own. And if you don't abide by all that, you're up for some gun grabs and people knocking on your door. Yeah, and again, this is a reaction to the Bruen decision in the Supreme Court trying to rein in states like California. They're mad that they don't get to just enact total control over their citizens in every way, shape, or form. And so they're introducing stuff like that. And unfortunately, in a state like California with the legislature we have, I think it's at least going to go through. 100% it will be challenged in court from the moment that piece of legislation is signed. I'll tell you, in the work I've done, I've seen all of the historical laws that start from 1500 all the way through present day. I've seen the states have submitted voluminous records of every law they can possibly imagine to justify essentially anything. I've read through every single one of them. I've gone back to the original texts of all these early laws. I've read them in detail multiple times over. I've argued them. And I'll tell you this right now, there is absolutely no justification whatsoever to that type of restriction. There's no historical analogous regulation that you can find anywhere before, during, or after the founding era. I'll tell you, they're probably going to try to rely on some late 1800 taxation regulations that were implemented in a number of states. Not that many, first of all, but that's probably what they're going to go on. These late 1800 taxation laws were placed on the commercial, Yeah, no. I mean, well, here's the thing, and this is the unfortunate thing about the law. One, you don't need a law degree to write law. These people write laws. They never went to law school. They don't have a law degree. I had to, pass the LSAT, get into law school, pass law school, take the bar exam, pass the bar exam in order to argue the law. But people just write the law, and they don't have to have any justification, certification, validation for it. So they just write what they want to write. And in legislatures that we have today, you get the unfortunate thing where they just pass whatever they want. They don't care whether it's constitutional. You've had California legislators that have literally said, I don't care if it's constitutional, we're going to pass it. And unfortunately, that makes it to where then we got to take it to the court system. And the way the courts work is everyone has their due process. You get to argue your case. So even though that by any common sense measure, anyone who has half a brain would look at this all and be like, this is absurd. You can't do this. It's unconstitutional. It's still got to go through the court process. And I'll say this, it makes me very supportive of organizations like the San Diego County Gun Owner Association in San Diego and other cities here in California, because their whole purpose is to get pro-Second Amendment people in the local representative capacity. Because what people do is they start locally and then they end up in your state and congressional legislatures. And those are the people that are going to pass the laws 15 years from now that are going to affect you in your everyday life. And that's how I always say this, like going to court, litigating stuff, that's the last step. You got to put out the fire at that point. It's much better to play the long game, make sure there's people that respect your constitutional rights in office, so where these things are never even proposed, they're never passed in the first place. And that's why I've worked with San Diego County gun owners for so long, because yes, the litigation obviously is very important. We got to fight these fires, but it's so much better when you don't even have to go to court in the first place. You have people that respect your rights representing you at your state, local, and federal level.
When it comes down to it, say I'm a judge, I do my decision. I don't have any way to actually enforce it though, huh? I'm dependent on the goodwill of the executive to carry, like say, any of these laws. I don't like it, I'm not gonna enforce it. What can you do, anything?
Well, unfortunately, in states like California, they have the mechanisms right now to enforce it, because when you purchase a firearm in California, that firearm is registered.
How's the court, say the court says knock it off, how, I mean, that's pretty words, but how does it get done? If the state.
Oh, well, so what generally happens when a court makes a decision, let's say they enjoin a law for being unconstitutional, they order the Attorney General of California to literally issue notice to every law enforcement agency in the country or in the state to, hey, this law, it's invalid, you're no longer able to enforce it. And if, I guess in your hypothetical here, let's say it's a local police station or agency or city said, hey, we don't care, we're going to do it anyway. Well, it makes it very easy to where you can challenge that, file a lawsuit. Yeah, you got to go through the courts. I mean, like I said, this is due process. Everyone's afforded due process.
Courts can't enforce themselves. They need somebody else to actually.
Well, the court enforces the law. I mean, in a situation like that, it'd be very easy to you file a complaint. You're gonna win right away. It's gonna be a 2-month long case because they're flagrantly disobeying a court order. So it would not. That wouldn't be like a long, huge, big delay or anything like that.
It's like when they like a decision, the next morning it's already in effect. Certain marriage laws change. They're issuing license the next day, but things like Bruin, like they're.
Yeah, and again, so a good example is, Bruin decision came out, said you can't have these extremely long delays or high prices and fees associated with CCWs. In LA County, they're being sued right now. It's another case in California because I think they admitted that it's a 1.5 year wait to get a CCW. I think it's over $1,000 worth of fees in order to do that. And when you think about that, what are they doing by doing that? They are literally stopping people from being able to protect themselves, and they're pricing out the public. They don't want people who are poor to have guns. Poor people shouldn't have guns. That is what the LA is doing when they issue something like that, when they have those fees. They're saying, oh, if you're too poor, you don't get to protect yourself. And it's disgusting. It really is. And again, it's just flagrant denial of fundamental rights. And we're going to hold them accountable, and we are. And we're going to, if we got to go all the way to the Supreme Court 10 times over, we'll do that.